Welcome, welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. For informational purposes only, I'm telling you that I am a professor of law at Mississippi College School of Law. I've been teaching in law schools and business schools for about 30 years now, but all interpretations here expressed are my own and are not to be ascribed to my school or to my students. Oh, we had another exciting day in First Amendment with my students' position statements. And if you want to read more, hear more about the process that we are using, take a listen to video number 22, I believe, of one of the previous ones. For now, I want to get right to it. So my students wrote position statements on current First Amendment conflicts. If there had to be a conflict, it had to be a current one, and they had to look at the positions different from their own, and also they had to take a position. These positions were to be supported by or informed by the First Amendment cases we have been discussing this semester. So today we have four that are tightly related. And so we're only going to do four this time. The ones I'm about to tell you about were all connected to either commercial speech or defamation or attorney speech as a form of commercial speech. Now, for commercial speech, we know that the court sort of placed it in the middle. Commercial speech is not to be false or misleading, otherwise it is not protected there. But if it's not false or misleading, it is any regulations on that speech is evaluated in the middle, not under strict scrutiny, not under low-level rational basis, but somewhere in the middle. So, well, let's just go to the first one. So the first position statement is titled as this: ethnic team names and logos, use of stereotypical, racist, and demeaning language and imagery publicly depicting Native Americans is protected by the First Amendment, though regulation of this speech is possible by means of trademark cancellation. So in his position statement, this student argues that the states cannot regulate speech, say, for example, where a team within that state names itself by a name that is racist or that is offensive or demeaning of some groups, especially as related to Native Americans. And you know, there's some ongoing controversies about this. He argues that the state cannot regulate or ban this speech. However, his point is it can be regulated by the federal government using trademark cancellation. Now, he says that no matter how demeaning or racist the speech is, he does not believe a state could ban it or restrict a team from naming itself as such if for a team within the state. Now, this is his argument. He says in order for the state to regulate that speech, the state would have to have a substantial governmental interest. And he doesn't believe that the use of such terms or racial slurs for a group for that the state, he does not believe the state would have a substantial governmental interest to regulate that. And he relies on some of the hate speech cases and some of the fighting word cases that we talked about earlier this semester. Now, one question I have, he says that it is to be evaluated under the middle, and under the middle level, where the government must have a substantial governmental interest, that speech cannot be false or misleading. And I don't think I got around to asking him whether it was possible that such speech is false and misleading because of the imagery and because of the descriptions it gives to non-whites. We didn't get to that question. Now, he also argues that even though he does not believe that a state can regulate such speech, he does believe that the federal government can regulate that speech through the trademark cancellation process. You know, to deny a trademark, or if a team has a trademark, whether they can cancel such a trademark. So he said he believes that the federal government would have this authority to regulate it in that way, but the state would not by banning the name, period. You know, it raises some other questions about teams that are named with names that are racially offensive, but they may be teams at public schools. So I'm wondering if it is a public college or a public university, would his analysis then change? Because would that then be government speech? And does a state have a right to say, we do not want to speak in that way if the institution is a state institution? So very interesting argument. He believes the speech can be regulated, but he thought only by the federal government and not by states. So what do you think? Do you agree with him or do you disagree? Okay, let's go to the next student's position statement. Now, the next two statements both address the unprotected category of defamation. Defamation, and we talked about the New York Times versus Sullivan, the Gertz case earlier. Defamation relates to the publication of a defamatory statement, of a falsehood about an individual that injures the reputation. In New York Times versus Sullivan, the court said that if this false statement is about a public official, and later the court said, if it is about a public figure, they cannot recover for defamation unless they are able to show that the false statement was made with malice or with reckless disregard of the falsity of the statement. So states cannot allow for them to recover under defamation unless the false statement was made with malice. Now, that is the case for public officials and public figures. Now, here is the next position statement. So remember that point. And let me point out also that the titles of all of these statements appear in the text box below, along with the cases they relied upon And you can Google the cases and can decide for yourself whether you agree with them or if you disagree. Okay, here is her statement. Rudy Giuliani would not be found guilty of Dominion Voting Systems defamation suit over false election claims. And look, I always have difficulty with Rudy's last name, so I'm just going to refer to him as Rudy. Now, Rudy was the attorney for former President Donald Trump. And here there is a current conflict, a current First Amendment conflict, because the Dominion voting systems that made some of the voting machines, they have sued Rudy for defamation. They argue that he made false statements about their equipment, saying that the equipment was faulty, but it was not. And they want to recover from Rudy for defamation, for damage to their business reputation, and other damages. Now, in her statement, she says that Rudy would not, in her view, Rudy should not be liable for defamation. Now, this is her argument. So the court has said that where there is a private individual, for a private individual, that person, a state can allow them to recover for defamation as long as there is a falsehood published if it is done negligently. Negligence is a very low level. But if there is a public figure or a public official or a public figure whose reputation has been damaged by a false statement, they have to show that the false statement was made with malice or with reckless disregard as to whether it was false. Now, Dominion voting systems, she argues it comes down to whether Dominion is a private individual, a private corporation, just making voting machines, just seeking to make a profit, or if Dominion is a public figure. Now, if Dominion is a public figure, Dominion must show that Rudy, right, that he made false statements, published them, and they were done, it was done with malice. So Dominion would have a higher standard. Now, ordinarily, the test for a public figure, not a public official is like a governmental official doing work within their work duties or what have you, but Dominion is private. So if Dominion is a private individual, private matters, all they would have to show possibly is that Rudy was negligent. That's a low level. But if Dominion is a public figure, they must show that Rudy acted with malice. That means with knowledge that the statement was false or with reckless disregard about the falsity. So the question in her position statement, she says the issue is whether Dominion is a private, like a private individual, where the government can protect to regulate the reputation more, or whether it's a public figure, meaning that in order for them to recover against Rudy, they must show that Rudy acted with malice. Now, she argues both sides, but I asked her a number of questions, and I find her argument very interesting. She says this. She says that Dominion is a company. And not only that, she says it is a large company that is publicly traded. So in her view, that makes Dominion a public figure. So in order for Dominion to recover for defamatory statements, Dominion must show that Rudy acted with malice, with knowledge of the falsity, or with reckless disregard as to whether the statements were false or not. And in her statement, she argues that she does not believe that Dominion will be able to meet that standard. She does not believe that Dominion would succeed in showing that Rudy acted with knowledge that the statements about the voting equipment being faulty, about the voting not being done properly with the equipment. She does not believe that the evidence is sufficient to show that he acted with malice. So what do you think about that? Do you think she's right? Do you agree or disagree? Do you think that Dominion voting, the company should win, or that Rudy should win? And if it turns on whether Dominion is a public figure, does that mean that every publicly traded company is therefore a public figure and should not have its reputation protected more like a private individual? That's an interesting argument, okay? So you keep a record whether you agree or disagree. Let's go to the third one. So as you see, there is great difficulty here with the defamation test. Defamation is in an unprotected category of speech. However, the court has said where you have a public official, they can take care of themselves. If someone tells a lie about a high-ranking public official, they can call a press conference and take care of themselves. So therefore, for a public official to recover damages for defamation, they have to show that the false statement was told with malice. That means with knowledge it was false or reckless disregard. The court later said that public figures are like public officials, that public figures can take care of themselves. They can call a press conference, right? They can do an interview to clear up their reputation. Private individuals may not have that opportunity. If I call a press conference, would you come? Would you come really? You know you wouldn't. But anyway, now, this next statement strikes at that very issue. Okay, here is her statement. Private individuals, public figures, and public officials, the standard should be the same. Now, her statement is based on a number of current issues where individuals who are celebrities or well-known individuals or individuals in the spotlight, they're not public officials, they're public figures. And she says in her statement that it's unfair, that they are often accused of things, that if they sue for defamation, they have to meet that high level. So in her statement, she argues that public public figures are really being treated unfairly. I mean, it appears that she's also arguing that public officials are being treated unfairly. She said the test ought to be the same. The test ought to be the same for private people, for public figures, and public officials. That our reputations should be protected to the same degree, and that states should not be allowed to protect the reputations of private people more than they protect the reputations of public figures and public officials, because she said the application is quite unfair for many different celebrities. Now, in her statement, she says that the remedy for all of this is to require that anyone who is suing for defamation, anyone, she doesn't care if you're a high-ranking public official like president or a member of Congress or a governor or a mayor, or if you're a public figure like you are a celebrity, right? Or you are a public figure, you've thrust yourself into the forefront of some controversy, or if you're just a private person, a teacher, someone working at the supermarket. She says all of our reputations should be treated the same under the First Amendment. She's in favor of more widespread speech rights. And so therefore, under her argument, none of us would be able to recover if someone published defamatory statements about us unless we met a high-level test. And she said it is only fair that the same test that applies to private individuals would be the test that applies to celebrities or people who thrust themselves into the forefront of a controversy, or a public official acting in matters related to their public conduct. What do you think about that? Do you think that under the First Amendment, states ought to be able to protect the reputations of private people more? Or do you agree with the student's position? And she says that our reputations ought to be protected the same, and for any of us to recover, we ought to have to show actual malice, meaning knowledge that the statement was false or reckless disregard as to whether it was false or not. What do you think? Do you agree with her, or do you disagree? Okay, make a note. Now, our final statement is by a student, and it really looks at a combination of commercial speech and also at attorney speech. It touches on defamation too. So I want to go ahead and discuss this one. We're going to cover it in class on Monday, but I want to go ahead and include it here. It is attorney speech. Here's her statement. Attorney speech, an ethical responsibility means constraints to First Amendment rights to freedom of speech. Now, we already said that commercial speech is evaluated in the middle. And even though commercial speech receives that middle level of protection, the court has seemed to give attorney speech even less protection. The court is concerned that attorneys like myself may use their speech not that I would, just doing an example, that attorneys may use their speech in order to take advantage of others for financial reasons. So attorney speech arguably receives even less protection than does commercial speech, arguably so. Now, in her statement addresses issues, I say it touches on defamation also. So online, there are all these different reviews that individuals can do. You can do a review after you stayed at a hotel. You can do a review after someone comes and does some repairs at your home. You can do a review of a restaurant. You can also go online and do a review of an attorney. So the question becomes, attorneys want to make a living too. So what if someone posts a review of an attorney online? They say the attorney didn't show up on time, is not smart, did not do good work, was rude, did not follow up. What if they say things like that? Can the attorney respond? Right? Can the attorney respond? Now, her statement is so very interesting. She looks at the approaches that different states take. Some states say, well, you can respond online, but you have to be careful that you do not disclose client confidential information. So if you respond online because a client has said some horrible things, the attorney cannot then badmouth the client and put all of the client's business out there. Attorneys, we are members of the bar in our state, right? We take an exam, go to law school, take an exam, have to go through an ethical examination before we can receive our license. And, there is some regulation by the state bars and what have you. So what if someone did a statement like that? Should the attorney be able to respond online and talk bad about the client and put all the client's business out there? Now, jurisdictions generally say, no, you can't do all of that. You're violating your attorney-client confidentiality. But on the other hand, if this person is bad-mouthing you, it can be affecting your bottom line. And the statements may be defamatory. Now, you can seek to sue the client in court, but can you just respond online? Now, this student, she told me that her view changed several times as she was working on this position statement, which is a good sign. Is showing that she's really thinking about the issues and weighing the ethical rules versus the attorney's financial concerns and all of that. Now, her conclusion is that the best approach by an attorney, if that horrible review is there online, she says the best approach, in her view, is for the attorney to type online and say something like this: I'm so sorry that you have a problem here, or you believe there is a problem with the services I rendered. Please contact my office so that we can discuss. Now, she thinks that's what an attorney can do. That's what an attorney can do in this balance of the ethical rules and this balance of the ethical rules of protecting the attorney-client privilege in terms of protecting the attorney's speech to some degree, right, in terms of addressing the attorney's economic concerns. She says when you weigh all of that, her position is you cannot talk bad back to the client online. She doesn't think the First Amendment protects that because attorneys are also officers of the court. And so therefore, they have fewer speech rights. Now, for my attorneys and future attorneys out there, do you agree with her or do you disagree? When someone writes a negative online review, should the attorney be allowed to just go all out against the person? Should the attorney be allowed to say a little bit? Or should the attorney be very limited in terms of what they can and cannot say because of other attorney obligations? A very interesting position statement. Look, we only have 4 for today. All of the students, I am just so proud of them as they think through these current First Amendment conflicts. And I tell them in class, just because I say that your statement was great does not mean that I agree with everything you said. But part of the experience of learning is to consider the support for our own position, but also to consider the competing positions. At the end of our last class meeting, we had some time and students were able to, if they chose to tell their classmates which of their classmates' statements they most agreed with or most disagreed with. And it was a very interesting time. And these statements cover so many different issues that people are arguing about. I was very proud of them to be able to disagree with each other in a professional way, though it may have been a bit intense. Okay, look, learning is so important. Learning is a pathway to enlightenment. And then I'm really hoping as we will move on to freedom, and freedom taking us on the path to justice, or at least a taste of justice. Subscribe and sign up for notifications. You don't want to miss any of these statements. I'll see you next week. Bye-bye.